Madam Secretary, please call the roll.
Senator Carroll.
Mr. Secretary, I'm sorry.
Here.
Senator Deneen. Senator Neal. Senator Nemus.
Present.
Senator Reed. Senator Stivers. Senator Thomas. Senator Wheeler. Representative Blanton.
Present.
Representative Burke.
Here.
Representative Decker.
Present.
Representative Dietz.
Here.
Representative Flannery. Representative Griffey.
Here.
Representative Kulkarni. Representative Chris Lewis.
Present.
Representative Derek Lewis. Representative Maddox. Representative Marzian. Representative Mosier. Representative Nemus.
Here.
Representative Petrie. Representative Roberts.
Here.
Representative Stevenson. Representative Whitaker.
Here.
Representative Williams. Representative Wilson. Co-Chair Storm.
Here.
Co-Chair Elliott.
I'm here.
Thank you. We have a quorum duly constituted to do business. At this time, I would like to recognize Representative Chris Lewis. I think he's new to the committee. Thank you for your service. And I'd also like to entertain a motion to approve the minutes from the November 7th, 2024 meeting.
Second.
We have a motion and a second. All in favor say aye.
Aye.
Any opposed? Ayes have it. Those are approved. At this time, we'd invite those individuals coming up to talk about the disaster response. Come up to the table and identify yourselves for the record, please, and you have the floor. Just make sure the green light's on. You can identify yourselves for the record, please.
Thank you. I'm Danny Rhodes. I'm the Executive Officer of the Department of Court Facilities at the Administrative Office of the Courts.
Thank you. Now it's on. I'm Kim Marshall. I'm the Franklin County Circuit and District Court Clerk.
I'm Judge Thomas Wingate. I'm the Chief Judge of the Franklin Circuit Court.
Thank you. And if you could just provide our committee a update regarding kind of what you all have been going through and future plans and things of that nature.
Thank you, Senator. I appreciate the opportunity to come before you all today. As you may all know, I'm sure you all know, in early April of this year, we had a catastrophic flooding across the Commonwealth. Of the 120 counties that the court system is in, 3 of those were affected by that storm. Those 3 are Perry County, Hardin County, and Franklin County. Perry County received basically some wind damage that blew off some of the roof panels that were around the cupola area. We did have water infiltration due to that, but that was quickly repaired. There was no impact to the court operations due to that. The second county that was affected was Hardin County. Hardin County received a large amount of rain from this flooding. That building is approximately 28 years old. This is the first time that they've ever received flooding in the basement area of that building. They received approximately 18 inches of flooding of water in there. That basement area is mostly unfinished, but it does house the court records for the Hardin County Justice Center, as well as the mechanical and electrical equipment. At the time that water took place, that water came in, there wasn't enough time to remove the files from the basement area. So there was approximately 3 shelves that were affected by that water of files. Court operations were suspended in Hardin County while we did an evaluation of the electrical, HVAC, plumbing, and to allow the water to recede. It did quickly recede from that facility, and about 24 to 48 hours, the water had completely receded. We were able to get ServPro in to address the water mitigation, but as we did an evaluation of the files, most of the files, even though they weren't underwater, were affected by the moisture in the building. So remediation of those files had to take place. The next county that was affected and greatly affected was the Franklin County Courthouse. There was approximately 4 feet of water by the time the water crested in the first floor of that courthouse. This affected the office of the circuit court clerk, which is on that first floor, as well as our specialty courts office and holding cells, and also security offices in that building. The other thing that was affected in this facility was the mechanical and electrical system as well. The mechanical electrical system in Franklin County was in far worse condition than we had in Hardin County. So in evaluating that after the water receded, we did pumping of the water because it was slowly receding. It basically took about a week to get the water completely out of that building. Once we did get the water out of the building, that's when the evaluation of the electrical and HVAC systems started. As ServPro continued to do the cleanup and deconstruction of walls and woodwork and things like that in the building, it was quickly identified that it was going to be a long-term repair to get the electrical panels replaced and all of the HVAC equipment replaced. So at that time, we decided to look at a temporary location for the Franklin County courts, and I'll let Judge Wingate speak more on this. But one of the first things we looked at was space that AOC was already occupying, or the KCOJ was already occupying, which was the Court of Appeals building and soon to be Supreme Court office on Chamberlain Avenue in Frankfort, Kentucky. We were able to utilize the courtroom in that facility and a conference room for the clerk's office and some adjacent offices. We quickly learned that that was going to be a temporary solution because as we make way for the Supreme Court to move in and this month to that space, we knew that with the repairs for the electrical in the courthouse, that was going to take longer than we had anticipated. So at that time, in discussions with our local judiciary, we decided to free up space at the Administrative Office of the Courts building that we normally use for conference area and move the court system into that area. That occurred June 2nd of this month, and they've been operating out of that facility since, except for in custody proceedings, and those are being conducted at the Frankfort Regional Jail. Would be remiss if I didn't thank everybody that participated in helping to find temporary options. Our local jailer, the Franklin County Fiscal Court, our judiciary for being patient and willing to work with our accommodations. So it was really a group effort to come up with a solution for this. The current condition of the Franklin County Courthouse, as I said, the first floor is basically completely gutted, and I'll share some of these images of the flooding that occurred. As you can see, there is a table in the middle of that lobby area that was completely underwater, and at one point it actually floated, that table. So there was tremendous amount of water and damage that occurred. The picture at the top right corner there, as you can see, that is when we first initially started having water come in. At that time, we were still trying to move files to higher levels throughout the building. At one point, with the water coming in, it was determined that it was too unsafe for staff. We had judges, clerk staff, AOC staff, jail staff, sheriff's office staff that were all moving files, but it was determined that it was too dangerous for us to remain in the building at the rate that the water was coming in, and that power needed to be cut to the building. So we were able to move quite a few of those files, but a large amount of those files were still damaged, and as in Hardin County, had to be removed and remediated. Once the water receded, as I mentioned, as you can see here, we had water up to the level of the floors, or the windows on the floors, the first floor. In our data and electrical closets. And once that water receded, then that's when the work of pulling all of that damaged equipment, damaged drywall, carpet out of the building and drying those spaces. Serpro did an excellent job of remediating the damage, but as you can tell, we basically had to pull all of the drywall out on that first floor up to about 7 feet because of the water that was in there for basically a week at that level. It just absorbed into that drywall. So next steps for the repairs of that building. Once we get electrical reestablished, we are fairly confident that we will have that within the next couple of weeks as they change out the electrical panels and do testing on all of those panels. We will then have to do an evaluation on all of the HVAC equipment, the plumbing equipment, pumps throughout the building, and then make a determination of what needs to be replaced and how quickly we can get operations back in that facility. As you can see from the images that I showed, we don't have the ability to use that first floor at this time. So the Office of the Circuit Court Clerk will have to, once we get systems reestablished, we'll have to look at options for alternate locations within the second and third floor of that facility. Covering the cost of this, I will say that this is a major catastrophic flooding event that we basically are having a lot of expenses accumulate on. So what we are looking at with Hardin County and Franklin County, with our file restoration cost, our building repair cost, the remediation cost of the cleaning and drying of the buildings, is about $11 million combined for those facilities. We are working closely with the Division of State Risk, CAICO, and Franklin County Fiscal Court to submit insurance claims for those. But I will tell you that the limit in Franklin County of what would be covered for that facility is $1 million. And that's insurance through CAICO. But one of the options that we are also looking at is FEMA funding and making an application for reimbursement of expenses for these damages. The county has contracted with a company that is helping them prepare the application for these damages. But at this point, there has been no federal emergency declaration for public facilities, so we can't make that claim until the time that is done. We do anticipate that there will be a gap between what the insurance coverage will be and what FEMA will provide for the reconstruction of these facilities. But we have to get these back up and operational and repaired as quickly as possible. So the court will need your all's help. And in Senate Bill 25, the restricted funds carry forward was placed into the Court of Justice reserve account. And we will need your authorization to access those funds to have the appropriate funds available to make these repairs for what that gap in what insurance and federal funding will not cover. So
I'd first like just to start by saying this is the worst flood in Franklin County history. My family's been around here since 1700s. Of course, I wasn't around, but this is my third flood. And this one was way worse than 78, and it was way worse than the 97 flood. Our architect never anticipated that this would happen. This is a catastrophic event. That day when I got the call, I immediately called Danny. Danny was already on his way. Before you knew it, I called Kim second, and I said, we got to move files. We started moving files. I wasn't much help. I just had back surgery, so I just I felt like I maybe needed to go buy him a case of beer or something. But, I thought, well, that's probably not going to work very well. I'll probably get in trouble for that. But they worked until 1 o'clock in the morning. We came back at 6. The only thing I could do was bring coffee. We worked until we were anticipating the water would start coming in at 2 from the hydrologist. It actually started coming in about, I don't know, it was like 10 o'clock in the morning. By 11, I ordered everybody out. I thought someone was going to get electrocuted. It was coming in that quick. So Kim has worked very hard. These guys, Danny Rhodes and Jason McGinnis, were there that night. They worked extremely hard that night, and they have carried us through relocating. It's really not that big a deal for me. I'm a circuit judge. I do everything by Zoom. We had good training through COVID. Our jail's been fantastic. I just walk in there and take care. We don't have to transfer any prisoners. It's working out really good. As you all know, since sometimes you all are in my court, it's Monday and Wednesday at 9. I just do it from my living room, okay? So it's working really well. The district court is a whole different matter, and the clerks are they're the ones carrying the ball, the clerk and the district judges. This is a very historical courthouse. Justice Harlan practiced court and held court in this courthouse. One of my ancestors was actually an overseer in 1835 for this courthouse, and I was on the project development board when we redid the courthouse, and we were a little concerned about putting the clerk's office in the basement. We don't like to call it the basement, but that's what it is, and it's the first floor, and we would really like to try to locate it. We think we have an ability to locate it. It was a courthouse that was built under budget. I know y'all never hear that, but it was. It was also a silver Leeds courthouse, and so we did build it under budget. It's actually smaller than what was anticipated and needed. We did not add a third floor to it, or actually a fourth floor, because the judges all get along. We share courtrooms. We have no problem with that. Nobody has a proprietary interest in a courtroom. Do y'all have any questions for me or anything? I know some of you.
Thank you for your presentation. I think Senator Deneen has a question.
Thank you, Mr. Chairman, and thank you all for coming today to present. I represent Hardin County. We were devastated with so much rain. One of the things, my questions are, you spoke of the basement there, and yes, I was in contact with our judges there, Judge Simcoe and others that were working on trying to alleviate that. There's also damage to the roof. That roof there is leaking badly, I guess, from from all of the rain as well. So my question is as you go back and circle back to assess all of the damages and get these figures, I'm assuming you've done that already, including the roof, and that is a part of the $11 million estimate that you're predicting?
The roof is actually a part of the asset preservation maintenance pool that the General Assembly generously authorized. So we will be utilizing funds from that to make those needed repairs and replacement if needed for our roof.
And one more, Mr. Chairman. You'd mentioned you'd been working hopefully to utilize some FEMA funding. Where are you in that process? I know my understanding from my own emergency management service director is that there is a disaster declaration for the PA side of things on the president's desk waiting for signature. So I don't know if you know of any further information on that regards for these particular areas that were damaged.
I don't, Senator. I will tell you that as far as the Franklin County building, as well as Hardin County in relation to that, we are working with a representative to prepare applications for that, to have those ready. And part of that is assessing all of the expenses that were either already, we've already incurred or will be incurring related to these events. So we're basically waiting on that emergency declaration to be signed. Once that takes place, we will make work with the county to make a claim on that.
And you are actively right now filling out those applications as we
Yes.
speak today. So there's no need to delay on that side of things, is there?
No, sir.
I do want to thank you for the electrical engineers that came down and did the inspections and got our courthouse back up and running very quickly. I made several phone calls in regard to that in conjunction with our judges, and I do want to thank AOC for moving that further along. So thank you.
And thank you.
Representative Decker.
Yes, thank you. Thank you for the presentation. I think it's a simple question, but maybe you can shed some light. Just given the fact that the second and third floors of the Franklin County have courtrooms and aren't damaged, I assume that needing to do electrical work and HVAC would require you to close it all, at least for a given period. But is there a time that maybe it's not finished in the basement, or that they could still go up to the second and third floors?
Yes, we anticipate that we will have power restored, as I mentioned, in the next couple of weeks. And once that occurs, once we get HVAC and data connections back into the building, we feel like that we can temporarily relocate the clerk to other floors and still operate. I think our judges have already developed a plan to share courtrooms so that the clerk can use some of that space, as well as file storage for that of everything that came out of the lower level of that building. So we feel like that even though that we have a long road ahead of us on reconstructing the lower level of that building, operations can continue as they were, with all court functions being conducted. I think Judge Wingate could probably speak to that a little better.
Yeah, we've already talked about that. I mean, if we can get into the second and third floor, we're ready to go. Everybody's familiar with those floors. We've already told there's a very large courtroom. It's what I generally use. It's called courtroom E. And then there's another one called courtroom D that Philip usually uses. We also use it for drug court, D. And then it makes it easy for them to figure out where to go. And that would probably be just totally designated as a district courtroom. And it's a very large courtroom, very nice.
Thank you.
Seeing no further questions, I did have wanted to ask a couple questions. the number of files you mentioned in Hardin County and Franklin County that were damaged, and you said they were being remediated or they were remediated, were those destroyed or were those just water damage? You were able to recover the information in those files?
Those have been removed from each facility. All that were water damaged, they've been taken to a third-party vendor to be dried, radiated, which basically any bacteria or contaminant that is on the records, they clean all of that. What can be destroyed will be destroyed. What we have to bring back after it's cleaned, we will do that and develop a plan of when that is brought back. The company that we're using is out of state. They've taken those files out of state, so they'll bring those back, and we'll at that point we'll determine a place that we can house those files and have those accessible to the clerk's offices.
Thank you. We have a couple more people with questions. Representative Cole Carney.
Thank you, Senator. Thank you all for presenting and for your, quick-mindedness in prioritizing staff safety. I did have a couple of questions moving forward. So once you've kind of gotten everything settled, my first question has to do with the record retention. You had people trying to kind of scrambling to get cases out, files out. What is going on in terms of digitizing records? And I'm sure this is an ongoing conversation, so I'm just curious as to where we are on that, because it would obviously have helped a little bit probably in this situation, even just as a backup. I'm curious specifically in terms of the timing and the cost to get something like that started or completed. And then my second question has to do, you had mentioned Senate Bill 25, and we need to authorize you all to use that funding given the timing of where we are in terms of session. What does that look like in terms of your need right now?
Related to the digitization of the files, we are working with our Supreme Court and state law librarian to kind of determine, how, what files we can, digitize, and whether that, we will still have to keep that hard copy record at that point. So I can definitely get you more answers on that. It's kind of out of my wheelhouse at this point, but we can definitely get you a better answer on that. Related to the funds available from Senate Bill 25, I'm going to ask our Carol Henderson, our budget director, to come up and answer that.
You do know we e-file. You understand that, I guess. I work totally off computer. I rarely see any kind of paper documents, not even in criminal court.
That was what I was curious about. What are these records that were being held in the basement and being moved?
The way I understand it, you got to keep small claims for 30 years. Is that right, Carol? And you got to keep any kind of closed circuit file for 15. That's sort of insanity. Okay, I mean, in my mind it is. I mean, why would you keep small claims for 30 years? I mean, I used to do those as a district judge. I think that we really need to look at record retention on some of these files, and I've destroyed some of them. Some of our criminal files, we destroy those all the time when they're over with, and they got wet. Some of them did, and so we have destroyed some of those criminal files that the appeals are over, Carol?
I'm Carol Henderson. I'm AOC's budget director. As far as Senate Bill 25, what Senate Bill 25 did in the last session was create a Court of Justice reserve account in our restricted funds, and moved, of our restricted funds, moved $30 million into that account. Well, in Senate Bill 25, we don't have the authority to spend it unless it's authorized by the General Assembly. So our hands are tied as far as that goes.
Until, I guess, until session.
until session.
Okay.
But like Danny had talked about, we're incurring costs. So, so there's a lot of costs coming up.
Understood. Thank you. Thank you, Chairman.
Last question on this topic is Representative Whitaker.
Yeah. So my questions were largely along the lines that Representative Kulkarni had about digitization of our records. As an attorney, I can't paper file anything. Much to my chagrin, I can't go over to the courthouse, which is one block over. I have to go through the CourtNet system. So I would love to hear from AOC on how we can finish the digitization, because as a practicing attorney, as my clients have to deal with, there is no paper option. So I'd like to get you all out of the paper business too, if we can't have that option ourselves.
I always thought you could still file papers if you're pro se. That's my, Kim can answer that, but if you're a pro se, you can file a paper copy. It's just if you're a lawyer. And we got some old lawyers that they don't want to do this either.
They retired.
Yeah. Well, I'm a young lawyer, and I don't like it too much because it seems like something always goes wrong with CourtNet right when I need to file something last minute. So.
Well, anecdotally, I was in a certain county yesterday, and I'd filed a document electronically back on, I think it was April 7th, and the prosecutor said he had not gotten it, even though I filed it through the electronic mandated system. So that's interesting to me. Thank you all for your presentation. We're with you all in this endeavor.
Thank you.
Thank you.
Next, I'd invite the next presenters to come up regarding the pretrial discussion. And as they're making their way to the table, this topic is on here because we have some, you all can come on up. We have some new members to the committee. Some new members were recently elected in the last couple of years. And so some of the terminology in this committee is unique. It's terms of art. And so I just wanted to make sure we gave everyone an overview of how this system works in Kentucky. And with that being said, please introduce yourselves for the record, and you may proceed.
Thank you. I am Angie Darcy, and I am the Executive Officer with Pretrial Services.
I'm Judge Stephanie Burke. I am a district judge in Jefferson County, and I am the president of the Kentucky District Judges Association.
I'm Julie Ward. I'm actually a circuit judge in Campbell County, and I am the second in chair of the executive committee of the Judiciary of the circuit judges, but I'm just here in a capacity as a circuit judge. So,
Hi, good morning. Jason Dufek, manager, Pretrial Services. Thank you.
Please proceed.
Thank you. Thanks for having us. So I just wanted to kind of go over the process of pretrial services. A lot of people don't know actually how internally we work, and I find it interesting. I actually was a public defender for several years, and I didn't know how the process works. So it's always good to kind of go over that and just just give an education. So we appreciate that. So Kentucky pretrial is actually a really good program. We're nationally recognized. We started in 1976 when bail bondsmen were eradicated by the Kentucky legislators. So Kentucky Pretrial Services was born, and we started with a phone and a chair in the jail. And that's how we started. So we've come a long way since then. And one of the things that we primarily do is assist defendants with their release from jail. And so I'll take you over the two main laws that we rely on for pretrial services. That is KRS 431-066, which states that we have to do a risk assessment on every individual that comes through. It has to be a evidence-based risk assessment. We also revalidate that every so many years to make sure that it's accurately doing what it's supposed to. Those 431-066 is the main pretrial law that basically gives you the low, moderate, and high risk. So if a defendant is low risk, then the court shall consider the pretrial risk assessment score. Low risk is actually established by the risk assessment, and the judge shall release on ROR, but can also establish conditions. At moderate risk, it's the same deal, ROR, but they can have greater conditions. They can also have things like electronic monitoring. And high risk, it's judge's discretion at that point. So 431.525 is the factors that the judge has to consider in conjunction with the risk assessment. So the judge doesn't solely rely on the risk assessment. That's just a tool for the judge to rely on. That will tell them what their risk score is. But the judge also has to go through what is the nature of the offense? Is the bail oppressive? Is it sufficient to ensure compliance with release? Is it considerate of the past criminal acts? And is it considered of the financial ability of the defendant? So if the defendant doesn't have money to post bond, then that shouldn't necessarily hold him in if we can get conditions that will ensure their cooperation with the bail conditions. So we have 275 employees with pretrial services. We serve 120 counties. We also are 24/7. And I think a lot of people don't realize that about pretrial services, but we have a first, second, and third shift. We work on the weekends. So we are very efficient with what we do with those 275 employees, and we try to get the job done as best we can. Sometimes we have staffing shortages, but at the same time, we have our statutory mandates, so we pull from other counties, and we do what we can to get the job done. We have 14 regions across the state, so we have a regional supervisor that supervises them. And, of course, I don't have to tell you guys that our population is about 4.6 million. So we have two different types of pretrial roles with pretrial services, two main roles other than management. We have the pretrial service specialists, and then we also have our risk assessment specialists. Our pretrial service specialists are the ones that oversee the interviews. So they will interview the defendant. They will then call the judge. They'll do the judge calls. They'll actually also go into court and talk to the judge about the risk level and give them our pretrial history to the judge. Then we also have the risk assessment specialists. What we found years ago is that our pretrial service specialists weren't so great at doing the risk assessment, and that was pretty critical. So they created a new role in about 2017. That was the risk assessment specialist, and the risk assessment specialist's primary responsibility is to grade that risk assessment and to make sure that it's accurate. We do evaluations on every single employee to make sure that they are doing the risk assessment accurately, because that's really important. So that is one of the main functions of the risk assessment. They also do quality assurance, and we have a very manual process. Our FTAs are sometimes hard to spot the way that they may be entered into the system. So our risk assessors also go in and make sure that those are cleaned up and that they are accurate, because one of the things that you consider with our pretrial risk assessment is whether they are low risk for failure to appear, and if our failure to appears, our FTAs are not accurate, then that may throw off our defendant scores. So I'll go over the pretrial process with you. So within 24 hours of booking, so somebody's taken into booking and a citation is entered, we actually manually enter that citation ourselves. We will type it into our own system, and that is our case management system right now is Interim. And we enter that into our own case management system, and we will upload that. That will be entered into something we call the queue, and the queue is what determines whether or not the risk assessor will catch that. And the risk assessor will then do a risk assessment on that individual. And then at that point in time, the defendant is interviewed as well. The defendant can be interviewed before the risk assessment is completed. We just have to get them interviewed. And one of the things that we do when we interview them is we ask about their job history. We ask them about some of their needs. And we also, the veterans question is a big part of us as well. So we also determine if they are veteran, so we can let our veteran,
Justice Outreach Coordinator.
Yeah, our Justice Outreach Coordinator get in touch and see if there's services for them. So we also, at that time, we determined by the risk score, there's two paths that they can take. The first path is the pre-arraignment release protocol. And if anybody is familiar with the pre-arraignment release protocol, that's an order done by the Supreme Court. And for certain low-risk defendants, low risk to moderate risk, class misdemeanors and class D felonies, just certain ones, nonviolent offenses and non-sexual offenses, it will release them automatically from custody. So they can either be eligible for our PAR program, and if they're not, then they have to be presented to a judge. Most of our defendants are presented to the judge. And then at that time, during a judge call, so we do judge calls, and you'll hear Judge Burke talk a little bit about that today. We do judge calls with circuit judges. They do indictments and indictment warrants, so that's a little bit of a different process, which you'll hear from Judge Ward today. But we do judge calls, and then the judge will determine, we'll read the citation to the judge, because they have to do a Riverside compliance, which means that they have to be interviewed and presented to the judge within 48 hours of their detention to determine probable cause. So we'll read the citation to the judge. We'll give the judge all the other factors. We'll give them the out-of-state criminal history. We'll let them know if they have an NCIC hit. We run NCIC on every single defendant that comes through the system. So we run NCIC. We let the judge know if there's an NCIC hit. We'll also do justice exchange. We'll do e-warrants, CourtNet, and then we'll also look at the COOL, the Kentucky Offender Online Lookup, to see if they're on probation or parole at that time. So one of the things with NCIC is we have to be really careful what we do with NCIC so we don't lose our access. We cannot put on our pretrial services report an NCIC, any NCIC information at all. So if somebody has an out-of-state record, we have to go and look at the out-of-state website to see if we can find that there's an out-of-state record. Now, that doesn't mean that we don't list that they have an out-of-state record. We still list that they have an out-of-state record. So for a state that has a private and we can't access it, we'll still put that they have an out-of-state record. We just won't list the charge because we're not allowed to by NCIC's rules because of confidentiality provisions, and we take our license very seriously. So if they do, so we try to do a lot of investigation ahead of time, and it takes quite a bit of work for our pretrial service specialists to go through this, but we try to be as accurate as we can. So that's really important to us, is accuracy. Okay. The risk assessment. So we use the public safety assessment. And the public safety assessment, I think there's a multitude of states that now use the public safety assessment. It's one of the probably the most popular tools. It's just a tool. One of the things that it does is it'll give you an actuarial score of the likelihood that you're going to come back to court or the likelihood that you're going to commit a new criminal offense. It's not always accurate, and it will actually give you like a score of its accuracy. So if you ever look at a pretrial risk assessment and see the top of it, it will actually give you the score that says, well, we're going to be 82% accurate that this person is probably going to come back to court, or this is the likelihood that they'll come back to court is 82%. So there's that, also that 18% that they could not come back to court as well. So that's why judges really have to consider the other factors in 431.525. And then a little bit about our pre-arraignment release protocol. That was it went statewide. It started about 2013 when we did some pilots. It went statewide in 2017. It releases low-level, nonviolent, non-sexual. In the beginning, it was just misdemeanors. Then when COVID hit, we really expanded it to try and get people out of jail because we were more concerned about, of course, them dying in jail. So we did a lot of releases. The Supreme Court expanded the order to try and get people out of jail. And it is now, as it is in effect, it's been, so it isn't as wide as it was during COVID. The Supreme Court has rolled it back substantially, but it does allow some Class D felonies to get out of jail. It was just amended a couple weeks ago to let no longer release Class D felony drug offenses on the pre-arraignment release protocol. So the Supreme Court made that decision. Judge Ward and Burke and Ward were part of that. They came to the Supreme Court and discussed that with them, and the Supreme Court made a decision to limit that further. So when pre-arraignment release protocol is not an option, it means that they get a judge call. If they are not released from jail or they cannot make their bail, then we will also schedule them for an arraignment date. Judges provided with the following items, and Judge Burke can certainly talk about this. They're provided with the citation. We read the citation. They're provided with our pretrial history report, and it goes over a list of things that we tell the judge, tells them if they're on probation and parole. It tells them if they're employed. It tells them about their criminal charges. It also has the risk assessment attached to it as well. And then we give them the criminal history for the judges. We can look and see if they have any pending cases or previous similar charges. We cannot give them a hard copy of NCIC over email, so we will read to the judge what their NCIC record looks like. If the judge asks for it. So we present all that. We basically follow the court's, what the court wants from us. So we are guided by the court. If Judge Burke asks for certain things, we will provide everything that she asks on that list. And then we take the decision, we put it into our system, and then sometimes we fax it over to the jail, sometimes we email it over to the jail, but we get it over to the jail as soon as possible. And if you'll see, if we can't contact the judge, we have something called a 24-hour rule violation. We take those very seriously. If we can't present to the judge within 24 hours, then we flag it for the next call schedule if we can't get a hold of the judge, if something happened with the judge. Sometimes we will also call the chief district judge in that region, or we will call the chief circuit judge in that region if we can't get a hold of somebody, because it's really important that we get these people presented to the judge and that we make sure their constitutional rights are protected. This is what a release decision looks like. This is kind of what our condition of release, this is our PT 35 form that we do. This is what we send to the jail. And then this is what the jail sends back to us. It's called a pink sheet. So that's what it looks like when they've released, and then we know that they've been released. We provide court coverage two different ways. It's up to the judge, and it's also, to be honest with you, it's up to, do we have enough coverage in that area? Sometimes we have staffing shortages. Sometimes we have staff going over to probation and parole or to other agencies. So it is sometimes depending on our staffing as well. But we can do two ways. We do in person. If the judge does virtual court, then we will attend virtually as well. We do the same exact thing that how we would do it in person. We present them with the pretrial history report, any pending cases, if a state inmate, how much time we expect them to serve, the risk scores, the bond, and what day they were booked on, and where they're located at the time. So if they're not in the local county jail, we'll be able to see where they're at, and we give that information as well. And then we also do a spreadsheet. Some judges are very technologically savvy and love the spreadsheet. So we can provide all of that in a spreadsheet. And we have a way, I would like to think that we're very efficient in pretrial services. Now there's times where we're not so efficient, and I will totally fall on the sword for that. But I would like to say that we're very efficient with pretrial services with our spreadsheet. This is something that we've actually been able to create that actually goes into the court record, and it kind of pre-populates itself, and then our pretrial service specialist makes sure that it's accurate. So we've done a lot of work on the back end to make sure that it's accurate on the front end. So some judges love this spreadsheet. Judge Cutoff in Christian County relies on the spreadsheet. A lot of circuit judges like the spreadsheet as well, so we provide that to them. Now let's talk data. So if you look, we're right around the same. Yeah, we're pretty consistent. In 2020, we did have quite a greater percentage of release during COVID. That's when we were releasing substantial amount of defendants on the pre-arraignment release protocol. And this year we're at 27% of our pretrial population is in custody. So total interviews and same-day custody status. So we actually track this daily. We'd like to know who gets out on a daily basis. Every morning I get this lovely little chart that's sent to me, and I look at it and I go cross-eyed because it's usually has a lot of information on it. But this is release same day, in custody hold, and indictment. Now you'll see that that indictment is almost none. That's because we don't have a lot of indictment warrants coming through with the pretrial system. So we don't have a large amount of cases. Those are something that we usually deal with the judge directly on. We either do indictments with them, but that's the reason why. Here's our pretrial success rate. So we're actually very much in line with the national average. Our FTA rate is right at 84%. That is the national average for people failing to appear. Not to worry, we are doing a lot of failure to appear initiatives to try to get people to come back to court. And we're doing a lot of studies to see how we can get people back to court, because we think that's really important. Because if we can get people to come back to court, it saves the state dollars. And that's one of the things that we are working on currently, is a lot of FTA initiatives. Success rate, the success rate combines the two. So it combines new criminal activity, the arrest-free rate, and it also combines our failure to appear rate. So it combines those. So we have a 79% success rate that is also in line nationally. And if you look at the very top, that is basically our public safety offenses. So anything that we feel like might be a public safety occurrence, like a DUI, for example, would be a public safety offense. And those are actually in line with our administrative release order. If it's a public safety offense, they will not be getting out on administrative release. So if you look at our public safety arrest-free rate, and this is also very comparable, I think our violent crime rate is something like 97%. There's not a lot of new violent crime or public safety offenses that are committed while they're out on bond. So that's a good thing. And I am going to go ahead and let Judge Ward talk about the pretrial process.
Sure. So normally, you all probably know that a felony criminal case starts in district court, and Judge Burke would be able to explain how that process works. But after the district court judge does their bail setting, then a defendant, if they get indicted, then a defendant would come to circuit court, and at circuit court, the judge can decide if they want to do a warrant on the indictment or whether they want to just keep the status quo for the bail that's currently set. If a warrant on indictment is authorized by the circuit judge, then we will set an amount that the defendant could be released on. And if a defendant is then arrested, pretrial will present to the court within 24 hours information regarding the defendant. Sometimes it's information that we might not already have, because before you issue a warrant on indictment, you're going to basically be really looking at the bail again. You're going to be looking at their criminal history. You're going to be considering the citation, the nature of the offense. You're going to be looking at whether the defendant ever had to be extradited. You're going to be considering whether the defendant is currently on probation but charged with a new offense. There's just a multitude of factors that the circuit judges look at to decide whether they want to do a warrant on indictment. You actually might have a defendant who has been on pretrial and just violated their pretrial release, which would make you want to do the warrant on the indictment. Just a variety of factors that we look at. And then once we determine if we want to do the indictment, they'll get arrested, they get represented, and then the court goes through the process all over again. We look at the nature of the offense. We look at their NCIC record. We take a look at their Kentucky criminal history. We look at, now does the defendant have a new address? Maybe the address they had before was bad and now they have a good one. We'll look at their financial circumstances again. Are they now employed and they weren't in the past? They also, if they had never been arrested at the district court level, but the circuit court has authorized an indictment warrant, we will then have a pretrial risk assessment report. I think you all know this, but a pretrial risk assessment report is never done unless a defendant is arrested. So a lot of times, although we're supposed to consider the risk assessment, if a defendant is being asked to modify bond, but they've been out, I won't know what the risk assessment score would be. But I'll have that new information if an indictment warrant goes out and there's an arrest. Then I'll have a risk assessment that I'll take into consideration. After the defendant is arrested, that gets represented. Then after representing, then we'll set the defendant for an arraignment. It has an affidavit of indigency, and at that arraignment process, we'll try to determine whether the defendant still needs a public defender. We'll see if he's a needy person or she's a needy person. If that is determined that they are, then obviously they get one appointed. And then the attorneys then can ask the court to look at bail again. They can represent a motion, and usually for me, that happens at the arraignment level. They've already pre-filed their motion. And so at arraignment, we're re-arguing the bail again. And we look back through all those factors again, in addition to whatever the attorneys might want to tell us. Sometimes we learn new information, good or bad, for a defendant at the arraignment process when the attorney gets an opportunity to speak to us. Pretrial in my county does not show up for court. They do a great job, but there's only a few of them, and to ask them to be in my court and district court would be virtually impossible. So they prepare all that information for me at the indictment level. I ask for all of it, and then when a defendant is arrested, I may, because I get the pretrial report, I might ask to see if there's any new run on the NCIC, if there's any new hits. One limitation I will say about the NCIC is I only have the state record. I do not have international records, I think, except Guam. I think we get Guam. Don't we get Guam? I think we get Guam. But other than that, I have no idea what anybody's criminal history is in any other country. So if they are someone who doesn't have a Social Security number here legally, I would have no idea what their criminal history is. That is a limitation that I may not have access to or have any information about when I'm setting bail for that kind of person. That's pretty much an overview. I don't want to be repetitive. I know Angie said a lot, so I'll turn it over to Stephanie, and if there's any questions you have for me, I'd be happy to answer. Thanks.
And Representative Elliott for having us here today. We always like the opportunity to explain what we do. In district court, as you know or may not know, almost all cases originate in district court, whether they are a misdemeanor or a felony or a traffic offense. And all cases where individuals are arrested are brought to district court first. So the district judges are setting those initial bonds. The initial setting of bond is done after the person is brought into the jail. They, pretrial, will do their risk assessment in their interview and gather all the information, and then they will call the judge. And there's a schedule for the judges, the on-call judge, throughout the day to take these calls. And during these calls, we may be presented on the low end, maybe 15 individuals. On the high end, we may be presented 50 individuals at a time. And so it's basically those persons who have been arrested in that period of time from the last call and been interviewed, and those interviews are complete and they're ready to present. This is an ongoing process. It never ends. And so We take those calls. When the call begins, we will speak with the pretrial officer, who will initially say, good evening, and this is how many we're going to present. And they'll just start going one by one. They will tell us the name of the individual's age, and then they will tell us the charge and charges. And they may say, this individual is here on a case of robbery in the first degree, but they also have 3 bench warrants for failure to appear, and then they have an outstanding warrant in Bullitt County, another county. They will go through and tell us the status of all of those cases in the other jurisdictions and the bench warrants, and then they will read us the new citation. They will tell us the risk assessment level for failure to appear, and they will tell us how many failures to appear that person has had in the last 2 years and how many they have had prior to that. They will tell us their risk for new criminal activity based upon the risk assessment tool. They will then answer any specific questions we may have about that individual's personal situation. I tend to ask, are they homeless? Who do they live with? Are they employed? What's their current status? Are there, is there any indication that there's any supportive persons in their family? A lot of that is something they will ask about, whether the person has a surety, someone who would be willing to come and sign a surety bond for them. That is something that is on the report. So there is a wealth of information just in that initial portion. The citation is read to us, and we are also given information about the specific criminal history. If there are failures to appear that were recent, they will go in and tell us about those charges. They will read information from the criminal history from the NCIC. So the out-of-state cases, they will read everything that they've got to us. If there is a fugitive warrant from another state, they will give us all the information on that warrant. They answer any questions that we have. Oftentimes we will ask questions that they may not have the information, and they will go back and try to get that information and call us back. So we make very well-informed decisions, I do believe, and I think that that is something that often is overlooked when people say, oh, these judges just let people out. Oh, these judges are just releasing people. These decisions are not made lightly. These decisions are made after considering many, many factors. And our duty is to determine, is the person a flight risk? Is the person a danger to themselves or to the community? We are required to consider the factors of whether the bond will be sufficient to ensure their compliance with any conditions that we may set, and commensurate with the gravity of the offense. And we must consider their past criminal offenses and any reasonably anticipated conduct if released. That becomes very important when we're talking about domestic situations. So if we have somebody who has a history, say, of repeat violations of an EPO, that reasonably anticipated contact, that's something we might be thinking of. And then the defendant's financial ability to give bail. Now, obviously, if we know that this is an individual whose only income is SSI, or they are homeless and unemployed, that is a factor. There are also statutory requirements on DUIs that out-of-state individuals are not to be ROR'd. We cannot just release out-of-state individuals on DUI offenses. There is a set amount of bond that we are required to set, $500 on a straight offense, $1,500 if there is an accident, $5,000 if there is a death involved. So those are statutory set amounts that we cannot set less than. And so the process of taking that initial call is the person's initial setting of bond, and that is constantly going on. What will happen is we have arraignment court. In Jefferson County, we have arraignment court Monday through Saturday at 9 a.m. We do our arraignment court in our jail. We have a courtroom in the jail. I've been doing arraignment this week. I go into the jail in the morning. I did this yesterday morning. I had 77 individuals on the docket. 77 individuals came before me, and I had the actual pretrial report in writing, everything that I had been read because I had been on call this weekend. I had set most of these individuals' bonds. I then had the actual physical report in front of me. Some of them had attorneys present, most of them did not. But it is very important at this stage, from my perspective, to see the individual. And I do think that there were a period of time where we were doing the arraignments on video. I am not a fan of video arraignment. Many judges are. I really like to get my eyes on that defendant. You can tell a lot by seeing someone about what their condition is, particularly if you're dealing with individuals who are suffering from mental illness and drug addiction. And sometimes I see people who are there and I can see that these are drug charges and their person is in such bad shape, it's obvious, and that really has an impact on how I set that bond. And so sometimes that is lost on video. So the person's brought before you. Obviously, we have a requirement to advise them of their rights. We then advise them of the charges against them. We have a discussion. I tell them when they come in there, please don't tell me any of the facts of your case. I don't want you to say anything that will incriminate yourself. Undeniably, every single time people come up and they want to start spewing things that are incriminating, every time. But what happens is that we start hearing from them. They will tell us more information about their finances. I tell them I'm going to ask them questions about their financial situation, which is related to the setting of bond, and appointment of counsel, because this is the phase where we will appoint a public defender if they so qualify. I ask those questions on the record and get that information, determine if they are eligible for the appointment of counsel at that moment. I also then ask them any information about whether they have housing insecurity and so forth, if they have anybody who is supportive of them. Sometimes there are people on Zoom. People can come to arraignment court by Zoom to observe. There are often family members, other individuals, lawyers also appear in person and by Zoom that will offer more information at arraignment court. Sometimes that information is very helpful. Sometimes the parents will come in and, like a parent may come in and say, he is off his medication. We haven't been able to find him for a week and a half. We're so glad he's there and he's safe. And so that information that sometimes we get from those individuals is also very helpful. We also have an officer there who has all the information on anyone who has a fugitive warrant from another state. That individual will have the information about those warrants, what the charges are, where they're wanted from, and any details. In the pretrial report, when we were physically in arraignment court, we are also able to see if that individual has any circuit detainers, any parole holds, other warrants from other counties, and we were able to see the amount on those and more information about who the judge is and get a good picture about what's going to happen when I set this bond. I may set this bond today and release this person, but that person is not getting out because they have all these other things going. Sometimes it is important for us to get our case, maybe it's a traffic ticket, resolved imminently before this person is let go. I may pass that case to tomorrow and leave a small bond so that we can pass the case to like the next day to try to resolve it, and then that other county can come and get them. So it frees them up. So those decisions are made in a very calculated way to try to resolve cases expeditiously when we know that other jurisdictions want these individuals. Arraignment court moves very fast. There is an extraordinary amount of information that we are required to consider. Most importantly, the safety of the community, if they are a danger to themselves or to others, and if they are likely to come back to court, are the most important. And so I I knew that I would be last, so I would like to answer any questions that you may have about this process. I know you may have some, so if anyone would like to ask questions.
Thank you all for your presentation. We have several members with questions. Representative Baumann to begin.
Thank you, Mr. Chairman, and thank you guys for your presentation today. I deeply appreciate this being a topic on the agenda. As one of the new non-attorney members of this committee, I have significant interest in this space and within the judiciary and plan to look at pretrial reform in the coming months and years ahead. I do have a few questions, but maybe we can get together after the hearing to talk more about these. I'll keep it to just one here for now. Can you please walk me through how someone that is a criminal or suspected criminal illegal alien, walk me through what the pretrial risk assessment process would look like for those individuals?
Yes, sir. The pretrial process would look no different for somebody that was an illegal alien versus somebody that was a resident. We have no way of knowing.
I can tell you that sometimes in the NCIC, when you're looking at it very closely, there may be some information in that NCIC that this individual has had some immigration information. It also may show their naturalization information as well. You also learn often that they are U.S. citizens, that they have gone through the process to become citizens in some of the paperwork that may come from that NCIC. But otherwise, there's really no way to know.
So what informs the decision-making process then for the judges if we can't supply the risk assessment for these individuals?
The risk assessment tool is always completed. For example, sometimes what will happen on individuals who I will ask if there's not much information, say for example, and it may be someone who has obviously not been a resident of the county for very long. I may ask the question, how long have you been in Jefferson County? And I mean, obviously, Jefferson County has lots of immigrants coming into county through Catholic Charities and other organizations who bring them there. We have many from African descent in other countries. We have many on our dockets who speak Kinyarwandan, so we're constantly I was using interpreters yesterday in arraignment court for different languages. During this period of time, I won't see much record, and sometimes they're unclear about date of birth, and I will ask a lot of questions of the defendant. And then most importantly is, how long have you resided in Jefferson County? Sometimes there are people from those charities on the Zoom to tell us how that person, arrived here, who the supporting agency is, and so forth. So these are not ICE-related issues.
Sure, that's how you manage the process. You have this, I guess I'll just call it arbitrary criteria that you would use.
We ask as much information as we can get.
Gotcha.
Hey, Representative Baumann, usually you'll know because you ask pretrial when you don't see a Social Security number. You'll ask them what the Social Security number is. You'll ask them to ask the defendant to provide a Social Security number. When they can't provide one because they don't have one, that alerts you that they're probably not a legal citizen. So when you don't have a Social Security number, you're limited to go through with what you have, which is all you have is what you have. So it's not arbitrary, it's just that's all you have. So there are some limitations. That's what I wanted to point out to you. What we do our best, but we're limited. Sometimes we will see on the NCIC record that there's an ICE, there had been ICE activity, and then they are, the ICE activity reflects that they were deported and came back, or they didn't show up for their deportation hearing. Sometimes we might see limited stuff like that, but we follow our criteria, but we're limited in the information that we do have, and there's nothing that we can do to fix that. I've asked and I've asked and I've asked, and there's just
Gotcha.
nothing to do to fix it.
So the criteria is, are they going to reoffend, and are they a danger to the community?
Yes, likely to come back to court and a danger to the community.
Right.
Yes,
and
sir.
we don't know the answer to either one of those. What do we do?
you have to make a decision as a judge as to whether you think, because you have no information, you know this person doesn't appear to be a legal citizen, you don't know their criminal history, you're more likely to assume that they are a flight risk.
Thank you. Thank you for some leeway there, Mr. Chairman.
Representative Banta.
Yes, please. First, Judge Ward, could you, we have your title incorrect on the, can you just clarify that for us?
Thank you. I'm a circuit judge. I've been a circuit judge for over 21 years.
Okay.
Thank you.
Thank you. And my question is, do pretrial issues, do you guys have enough money to drug test, to do things like that so that we know what's coming into the jail or what you're dealing with?
So we don't drug test when they come into the jail. That's up to probably the jail to do a medical and check and see if they're on substances. Like the jails are required to make sure that the person coming into their jail is safe to be in the jail. However, pretrial doesn't have any money to do drug testing. That is by statute is passed on to the defendant. So there may be drug testing that's ordered through our monitored conditioned release program, but we don't, the actual defendant has to pay for those tests. So
the process, when a judge sets a bond of any amount, we also set conditions. I have a number of conditions that I set on almost every case. One is make all scheduled court appearances, have no new offenses, no alcohol or drugs. Many of them is to not possess a weapon or firearm. And then we get into the weeds of like no contact with this individual, no contact with this place of violation. Oftentimes we'll put scram monitors on alcohol-related offenses. You know, that's an alcohol-related device. We might put someone on home incarceration as a condition of the bond, meaning if you post the bond, you're going to go to home incarceration, which has obviously significant supervision. But we also have the ability to order monitored conditional release, which is not a bracelet, but it is reporting supervision. And I will order them sometimes to be assessed by 7 counties for a mental health evaluation or a substance abuse evaluation as a condition, and also to subject to random drug or alcohol screens. Unfortunately, those individuals are required to pay for that themselves.
Thank you.
Co-Chair Elliott.
Thank you, Mr. Chairman, and thank you to everyone for the informative presentation. I had a question related to what I would call the duplication of bonds. And is that an issue that either of you see, and it would primarily it would occur, obviously there would be a bond set in district court, the case would typically be a felony and would then go over to circuit court, and you have defendants having to typically post 2 different bonds. So is that an issue that either of you have seen, and if it is, how do we address it?
The practice is that the district court cases pending, typically the probable cause hearing, the initial preliminary hearing is in front of the district court. Then the case is sent to the grand jury and we await indictment. If an indictment is issued, then the case would be sent to circuit court for them to review, rearrange, but the case comes back to district once the indictment is issued to dismiss it without prejudice in district and release our bond. So that process happens so that district case is closed, because only after we have confirmed the case number and it has been set with a bond in circuit. So that practice, I assume that's how you do it.
And even if we don't do it that particular way, when a circuit judge is relooking at the bail, you don't have them post double bail. You would just say, this is a new amount. So the old amount is waived because the district judge doesn't have any jurisdiction any longer. So whatever I do replaces whatever they did. So there won't be duplicate. But I will say that I think the process works because of the fact that there's stages of protection, not only for the defendant, but for the community itself. Meaning at the district court, you start off with a police officer arresting someone. Then that's one branch of government. Then you have the judiciary looking at it and making determinations. And then you have members of the public who are now making a determination. So at every level, there's more eyes on it. And when you get to the point that someone is indicted, meaning the community believes that they have likely committed the offense or that a crime has been committed, that's a new level that the court has to recognize. There's another set of eyes that have looked at this. And that's a change of circumstances, which results in the circuit court having the authority to look at the bail anew. So there are these protections, not only for the defendant, but also for the community themselves. Meaning if you're seeing like at the district court level, you might have someone who's charged with you might have someone charged with a murder, and you might get at the indictment and it's wanton endangerment. I'm not going to keep the bond at $1 million on a wanton endangerment charge. I'm going to reduce the bond. So there are protections either way. That could go the opposite. You could have the indictment that it turns out that the wanton endangerment is different than that. The person has died. They've changed it to a different indictment entirely. So, the circumstances change, and it's just that level of protection, knowing that different eyes are looking at it at every stage. We call it layering. A lot of judges do. So it's not duplicate. It's important, I think.
Thank you. That's helpful.
We have Representative Roberts.
Thank you, Mr. Chairman, and thank you to the individuals presenting. This is an incredibly important issue because these people are presumed innocent, but at the same time, we have to balance that with the interest of public safety as well. So I have a couple of questions. The first one, these are more substantive, but then I'm going to get into a procedural question. So sort of piggybacking off of Representative Ballman's question, do the RASs or the PSSs, do they take into consideration at any point in the pre-release of the existence of an ICE detainer?
No, because that's really not information that we're supposed to be privy to. We're running NCIC solely for the purposes of determining criminal history, and that's kind of our agreement with state police. So we don't, we can't get into that portion of it, and that is a greater level of scrutiny with NCIC because it is called. And I can't remember the exact word, but it's unverified. Typically, NCIC is not always accurate, so it's unverified. So we have different levels of scrutiny, and even though it might be available for a pretrial service specialist to read or a risk assessment specialist to read, we're not really authorized to communicate that because we're limited by our NCIC agreement.
Okay, and so beyond NCIC, suppose it's at the offense at hand. Is there anything under state law that is prohibiting you guys from taking into account defendant has been arrested this evening?
I think what there might be a confusion here is that we're talking about state courts. We don't have access to federal records or INS records to even indicate to us that someone would have an ICE hold. I have no access to any database that would give me any information about an individual having an ICE hold.
Certainly, and this more on the pre-release part because I know that they tend to work within the jails with the police departments. I'm thinking about like in that present offense there, right? They commit that offense, ICE contacts that specific arresting department. I'm just wondering if there's anything under state law that's prohibitive of that type of coordination, of letting it be known, like department lets you guys know, hey, we just received this from DHS ICE.
So our pretrial services information is confidential by RCR 4.08. So we're really only authorized to tell the judges what we know, and then additionally, they don't inform us of that information. I don't even think the jail knows that there's necessarily, they might get a holder coming in, but that's not something that we're ever really privy to.
Okay.
In 30 years of practicing law and being 15 on the bench, I have not had an ICE detainer come up in a case once. Never had ICE notify on a case, never had somebody taken from ICE during a case. I understand that on a national scene there's a lot of discussion about this right now, but this has not been an issue in our state courts.
All right, thank you.
I will say, as a circuit judge, I've had ICE that when I first hit the bench, ICE would come to the courtroom and they would take them right from the courtroom. So I've had that experience, and then it changes over the years, different policies happen, but it has happened. And then they do coordinate with the jails, I think, to make sure that those are effectuated. So hopefully that helps. But I will say one little plug, if you could help us, the NCIC record, we judges, we're not allowed to touch it, hold it, feel it, unless a pretrial officer gives it to us. The state police will not authorize your circuit judges to have full access to it. So if I wanted to run my own NCIC record on a defendant, they won't let me do it. So if there's any way that you can assist the circuit judges and the district judges in that, I would love that.
That's if FBI controls that, correct?
Yes.
Is that FBI?
I think that is correct. But
okay.
If there's anything you can do for us.
The FBI controls that, correct?
Understood. And so on to
One
my
last question.
Yes.
Okay.
Yeah, I just want to get into this in terms of, because right now we have about 100,000 individuals who were released in 2024. That's about 2% of the Kentucky population. It's not a small number who's going through the criminal justice system. But I was just curious, what is the breakdown on the offender level on this? Is that how many of those are felonies?
We'll have to get back to you on that. I can look at that and follow up on that, because I don't know it right off the tip of my hand. I will say that the majority is misdemeanors, and our felony cases it's probably it's probably about 3 to 1. So probably about 25% are circuit court cases, maybe if even that. But we'll get you that data.
Thank you.
Representative Cole Carney, then Decker is on deck, and then followed by Deneen.
Thank you, Mr. Chair. Thank you all for this excellent presentation. I was wondering if you could go back to the slide on success rates.
Sure.
And just I think you passed it.
It's the little squiggly line.
Yeah. And just, I wanted to understand exactly what you were saying. So you're at about an 80% success rate, and that is a combination of all of the lines?
It is a combination of all the lines. So, and PS arrest-free rate is kind of an outlier there. It's not really a combination of PSS arrest-free rate. It's really a combination of our arrest-free rate or our arrest-free rate and our appearance rate. PS arrest-free rate is kind of just in that data already.
Okay.
So those are everybody that has come back to court and not having a new criminal activity.
Okay.
Okay.
And how does that, I'm sorry, Mr. Chairman, just a few follow-up. How does that compare, I guess, in terms of benchmarks with other states?
It is right in line, and we learned that this weekend last week that everybody is basically at that same level. Like, that is consistent with what other states are showing that have national databases.
And is there, final question,
Sure.
This is based on the criteria that you've already laid out that applies to everybody that comes through the pretrial system. What are some trends or recurring reasons for that 20%?
For the new criminal activity or I can say this, with new criminal activity, I think it's always hard to determine, right? But with failure to appear, we have done some studies that, and that's one of the things that I think that we can work on, is getting people back into court. So those are some of our initiatives. And we've done some studies, and sometimes it's childcare, sometimes it's just that they're scared of court. A lot of times it's just that they forget. So those are some of the initiatives that we're working on with court text reminders, calling them, and also seeing if there's any barriers that we might be able to help them with and get them back into court.
Thank you. Thank you all for this excellent success rate and for the work that you all do with, limited information. And just as a reminder to everybody, immigration violations are civil law. This is a pre-trial system. These people have not been adjudicated or gone through trial. And so it is important for us to keep the factors and the metrics that you all have in place, given that it is working. Thank you.
Representative Decker.
Thank you, Mr. Chairman, and thank you all for your excellent presentation. I have talked with Judge Burke at some length and will continue to about fines and fees and pretrial costs. I was interested when you were talking about pretrial assessment and the drug testing, and I understand that it's the cost that is borne by the the defendant, and that. So my question is, if they can't pay for it, I understand that they are then presumed to have a positive result if there is not a fee paid. And I'm thinking about the fine line that we walk between presumed innocent and public safety. I think Representative Roberts stated that well, but who bears the cost of each of those? So if someone, is there a finding? I guess my question is there a finding of indigency before there is a presumption of positive result?
So let me say this: we do run for the courts that where we monitor drug testing. We do make our providers sign a memorandum of understanding that makes them do an indigency determination, and on some of those they have to waive like a certain percentage. So if somebody is indigent and they can't afford the test, then they have to be willing to waive a certain amount of those. We also encourage our clients, even if they can't test that day, to show up and say, I can't afford to test because I don't have the money, but I'm here and I want you to let the judge know that. And then the court will know that they at least showed up. And it wasn't just, I couldn't pay, so I didn't go.
Just one quick follow-up. I think you said that's what you do. Is that the requirement for what you just said, or is that
No,
just
that's
practice?
just what we advise from pretrial. We tell them to go anyway. If they can't pay, we ask them to go, and then the judge will be made aware that they can't afford the test.
Thank you.
Senator Deneen.
Thank you, Mr. Chairman. Representative Kilcarney addressed one of my issues on the chart there. My concern is with those that fail to appear. What statistics do you have on? I've gotten this question. I guess not really a statistical question, but I've gotten this question from some justices from Hardin County. How long does those individuals that fail to appear, stay on the run, avoiding capture or avoiding warrants that have been assigned, and they are, say, finally arrested and brought before you? Is there a time frame? Is there a time frame for that before you wipe out or consider that as probation, that they're on the run, or when does their probationary status start if they have avoided capture? Is there a time frame for any of that?
Sure.
For failure to appear?
Senator, typically when somebody fails to appear, the judge will issue a warrant, and that warrant will stay active for so long as that person continues on the run. Now, there's some periodically files are reviewed by prosecutors, by the court, to determine whether, a lot of times it has to do with the record retention schedule. Now, on occasion, they will set those warrants aside if it was for a minor offense or if it was for a violation or something, but there's no hard and fast rule. So that warrant will stay active for so long as the person remains on the run.
We see people getting picked up on warrants that are 25 or more years old.
Is there a 5-year time frame on any of these?
No, so Senator, I will tell you one thing that we do in Campbell County is we get every quarter, the Administrative Law Courts runs a log of your cases that are active pending, warrants that are issued. And in Campbell County, we will make sure that we contact the sheriff's office and say, hey, these are all our pending warrants. Let's see if we can get them served. So they actively do go out and try to serve these warrants. It's just when you have an address that the defendant has given you on your bail sheet or given to the district court, this is the address that I live at, and then they move, it's really difficult to find out where they're at when they've moved. They've told you, this is where I live, this is where you can find me, and you try, and then they don't come to court. And then you've asked the attorney and you've asked everybody and their brother, is there any other address that we might have for this person? And nobody has any other address, because if they do, you'll send out another summons potentially to that address. So there's only so much we can do, so we don't quash warrants on people who are purposely failing to appear.
just follow. So if someone does avoid capture, they fail to appear, they're on the run, and they are eventually arrested, are those folks being held accountable for those original warrants or because of a length of a time? Are those waived, or those types of? I guess I'm trying to get to a question that
the warrant stays the proceeding. So if the person is gone for a year, when they come back, you just pick right back up in wherever the phase of the proceedings were at the time that they absconded.
Okay.
So I will say that you would be surprised at how many people who have giant stacks of warrants. So somebody who may have 12 cases and they're all warrants, and that person is going to get picked up, and all those cases are going to get come back. There's also, unfortunately, we find that there are many warrants where the defendants are deceased. Because of the opioid crisis, there are many warrants in our system.
I just want to make sure that those folks that are on the run that have not failed, that failed to appear, are held accountable.
Yes.
Despite not committing another crime in the time period.
So those cases still exist and are still handled as if it just tolls the time. It stays the proceeding until they're brought back before the court.
Thank you.
Representative Dietz.
Thank you, Mr. Chair. I think we heard something about personnel, so I'm wondering, how are you all looking? Are there personnel shortages, and is that along any kind of rural urban line, and if so, is there anything the General Assembly can look at next session to assist with that?
Sure. Thank you for the question, Representative. We are continuously looking for employees. If you hit our website, there's almost always advertisements on there for pretrial service specialists. It's hard to maintain that staffing level. It's harder in the more urban areas than it is in the rural, but we struggle everywhere. Like Angie spoke about, working 24 hours a day, 7 days a week, 365 days a year. It's hard to maintain that staff, especially, nobody wants to work nights on the weekends, and we have to have folks doing that, going into jails. We could get you some statistics on that we don't have with us, but I can tell you just anecdotally, it's a struggle. We're always hiring.
And I think if you could just provide that where the shortages are, that might be helpful.
Yes, ma'am.
Okay.
Yeah, we would be happy to.
Thank you, Mr. Chair.
Seeing no more active questions, I did want to take chairman's privileges for a moment, and this might go more toward the judges, but in Laurel County, our docket's pretty hefty, and every Friday, this answers your question to an extent, Senator Deneen, but every Friday, our district judge has every person, that case may be 4 or 5 years old. They'll call the case, call them out in the public. If they're not there, issue a warrant. In the circuit court realm, what they do is, and I don't know if you all do this in your area, Judge Ward, but the docket can get so jumbled with these docket calls, and that defendant's never going to be there or hasn't shown up in 2 or 3 years. Rather than calling that every single time, they put it on an administrative docket, so it's there. And then when the person does get picked up, then they bring those individuals in to answer and stand for those charges. That at least helps the docket be cleared up a little bit. But thank you for your presentations. I did also want to mention that I appreciate AOC and I'm sorry, Pretrial, and Ms. Darcy and her work with her team. We were recently in Chicago, and believe it or not, Kentucky is probably, well, it was said that we are the Cadillac of this avenue, this pretrial system. So most cases in other states, they can't tell if somebody's got a charge in Paducah or Pikeville. The judges don't talk to each other, and so I'm glad that you all are working together, and we're all working together to try to make the Commonwealth a safer, more productive area. Seeing no other items on the agenda, we are adjourned.